Hello, everybody. Happy Friday. I'm Anjanette Levy. And if you are just a first timer joining me here, welcome. And thank you so much for hanging out with me on this Friday. It's rainy, rainy, rainy where I am. So if you're inside hanging out in the rain or out of the rain, thanks so much for doing that. If you are somebody who's been here with me before, thanks for coming back. I really appreciate it. Remember, please give me a thumbs up, hit that like button and subscribe. I'd really appreciate it. I'm trying to grow my little channel here. And there's a lot to talk about. Let me tell you, Judge Hippler has dropped some more orders. And the big one is on the death penalty. It was on the second try for the defense to, or second request for the defense asking him to strike the death penalty. They lost on the first go around. They lost this one too. Messica says hi from Chicago. Thanks for watching from Chicago. Tayo Toys. Thanks for coming back, Tayo Toys. Tayo Toys always brings the jokes. So I'm glad he is here because he makes me smile. So if you ever see me reading a comment and smiling or laughing or snickering, it is certainly not at the very serious content that we cover here and that we talk about. It is because he sometimes really makes me laugh. And a lot of you make me laugh, which I really appreciate because we need some comic relief in the middle of these cases that we cover. But before we get to Bryan Kohberger, can I just say, Karen Reed, whoa, Nelly, Karen Reed. So I would like to know, and maybe I should do a poll. I would like to know, I think I'm going to set up a poll really quickly. I should have thought about that. I want to know if you guys want me to talk about Karen Reed, because I talked about her on here last week. I did kind of like a threefer. I talked about Lori Vallow, Bryan Kohberger, and Karen Reed. And, I don't know if people liked that or not. I'm trying to kind of figure out what people like because I am interested in a number of different cases. Obviously, the Idaho case is one that is really, really big and very, very important. All of these cases are important for different reasons, but and that's one that I've focused on a lot here. But the Karen Reed case is one that I've been interested in for a really long time. And let me just tell you, it's really something. So let me see. I think I can do a poll here. I don't know. Start a poll. Yeah. Yeah, I should do that. Would you like me to do a live on Karen Reed? So I'm going to start this poll because I would like everybody to answer that because I'm thinking about doing one tomorrow, like my own, like a separate whole live show on Karen Reed, and basically what happened this week and my thoughts on it. Because, wow, that's all I can say. Wow. But you came here to talk about. You came here to listen to me talk about Bryan Kohberger, so we will get back to that. Cindy says, whatever floats your boat. That's very sweet, Cindy. And Cindy's actually going to come. Cindy is going to come on and talk with us one time. I met Cindy when I was out in Idaho one time, and I actually interviewed her for Long Crime. She appeared in a special I produced. So, and we've talked texted and stuff like that. So, she's going to come on and talk with us sometime. So that's going to be a treat. She has some inside info. Dead in the Water says I voted, but I'm not telling what I picked. So yeah, I'm trying to think about what time I should do that tomorrow. If I do that, life just happens sometimes. You think about things you're going to do and you want to do, and then life happens. So, but all I got to say is, wow, Karen Reed. That's all I got to say. So let's get to the Bryan Kohberger case right now. As I said, Judge Hippler, I call him Judge Dry Sass. He dropped some new orders. And, he's always got some new nuggets in there for us, which I appreciate. I like new information. And so sometimes it's just little bits of info, and sometimes it's just it is what it is. But I always appreciate any little bit of info, like whether it's just a little bit of color or whatever. Tayo Toy says, "Oh my God, Anjanette, avoid Karen Reed, please." Really? Okay. Well, I just started watching the documentary, the ID thing, last night. Looks like it's pretty well done, and it's like a star player. It has a starring role in the retrial, so it's interesting. So Judge Hippler, Judge Drysass dropped some new orders, and remember, Bryan Kohberger's lawyers were saying, "Hey, we need you to drop the death penalty because Bryan Kohberger has been diagnosed with autism spectrum disorder, and he's apparently level 1. There are 3 different levels of autism spectrum disorder. This is what I'm learning reading these motions and stuff. And I think I've told you guys before that I think I've told you that story about how when I was a substitute teacher way back when, and they put me in a special education room for the day, and I was like, I just don't think you should be doing, I don't think it's fair. Like, I have no training in that. I just don't think it's fair to the kids. And they were like, well, you'll have a helper in there. It'll be okay. And there was just this sweet boy who had, he was on the autism spectrum. He was nonverbal. What a sweet child he was. He probably was like junior high age. And then like I turned my back for like a second, and I turned back around, and he had like Windex or something, and he was like spraying it in his mouth, and I was like, oh my God, like I was like freaking out. Bryan Kohberger is not that guy, is not that kid. So Bryan Kohberger is level 1 autism spectrum disorder, where they said he needs like supports, and he's socially awkward, not real good with social cues, kind of talks, very formally, things like that. So I'm going to play a little clip of his one attorney, Alyssa Masseth, talking about what his autism spectrum disorder. Basically, the U.S. Supreme Court in the Atkins decision said that people who are intellectually disabled, like if they have an IQ below a certain level, if they're considered what used to be called mentally retarded, they should not be eligible for the death penalty. I think everybody can understand that, right? Bryan Kohberger's not mentally retarded, okay? Or intellectually, they believe, his attorneys, I guess this is a different point of view, his attorneys believe he is intellectually disabled, right? The state doesn't believe that. And it sounds like the case law doesn't support him being intellectually disabled. So let's listen to Alyssa Masseth talk a little bit about this.
Which apply here are A, less able to give meaningful assistance to their counsel. B, demeanor may create an unwarranted impression of lack of remorse for their crime. He may understand the definition.
Oh, sorry, I screwed up my stuff. Here, let's play that again. Sorry, I uploaded another clip. Hold on, here we go again.
C, typically poor witnesses. And D, mitigating evidence of ID can, quote, be a two-edged sword that may enhance the likelihood that the aggravating factor of future dangerousness will be found by the jury. All 4 of these impairments apply to ASD generally, and to Mr. Kohberger in particular. As to less ability to give meaningful assistance, extremely rigid thinking, he perseverates on specific topics, processes information on a piecemeal basis, struggles to plan ahead, and demonstrates little insight into his own behavior and emotions.
Okay, so that's Alyssa Masseth basically saying all of the things, that this Atkins case basically says he, like the criteria he fits into, why he qualifies for this. Then she talks about how like he's not able to help them with his defense. In the, like, say they get to say he's found guilty and this case goes to the penalty phase, as they say, they call it phase 2. They want to present evidence that's mitigating. And she's saying he doesn't really get that, like get what is mitigating. So here, listen to this.
Of mitigation.
Sorry.
He may understand the definition of mitigation, but he has no ability to assist us and understand if what might be mitigating and why. The impairments that he has go all the way back to his very young years, where he walked on his tippy toes, rocked on all fours for extended periods of time, could not engage in imaginative play, wrote his fives upside down and backward. He was provided with extensive supports in school. He was evaluated for ASD, but not properly diagnosed. And bring that to current time, where he is at age 28, where he has few personal relationships. He does not have any insight into things like the fact that he once volunteered at the Special Olympics is mitigating, or that he helped save someone's life on the job, and that's mitigating. He can see the logic in the word mitigation, but he has no ability to understand and help us develop a case for him for mercy. His demeanor, he has a limited range of facial expression, odd eye contact, and intense gaze with subtle rocking, sitting very still. This is important because of the impact that jurors assigned and give.
I kind of watch as he kind of, as she's saying all this, he kind of like is looking at her, and then he kind of looks over like this. He kind of like looks over to the side. And somebody commented when I made a remark about this the last time. And I'm just saying, all I'm saying about that is that I look at him and I just kind of, like, obviously this is not, we take what we can get with this case, right? We've got this Zoom camera. I'll take it because it's better than not having a camera in there at all. But we can't see his face clearly. But it just almost looks like he's kind of like, okay, really? Like, I'm sitting right here. Like, what you're sitting here saying all this stuff about me. Like, me, it's just the way he is, right? I mean, I don't know.
Tremendous weight to perceived remorse or the lack thereof. So again.
Okay. So there you have it. And then she said, and then their other argument was the media has vilified him over the last couple of years. The media has like said terrible things about him, analyzed him. They've even pointed to the place where I work, something that was produced about his body language. I'm body language. I'm like, sometimes I think some people are very good at that, but I think, I'm not going to comment one way or the other. I think, ascribing, looking at a photograph of somebody and, trying to say they're this, that, and the other. I'm not sure that's fair. But here she's going to say like everything the media has done to basically make him look horrible.
Years of media coverage to know how Mr. Kohberger's physical presence has been perceived. The state might have a little bit more credibility with that argument that it's not relevant, but we have extensive media coverage that refers to him as evil, as an incel, as looking like a monster with very dark eyes, and it's all based on their analysis of him sitting in the courtroom. Pardon?
None of that is his autism spectrum, what you just mentioned.
But his physical presence is what the media has been judging, which is the same thing that a jury is going to do. So my point is that for the state to say that it's not relevant, we actually have in this situation the ability to point you to the fact that that is not true. Because what the media has done, I mean, there are, even before the cameras were cut out of the courtroom, there were all kinds of zooming in and stories with experts doing body language studying about him, including the fact that this is how he holds his hands, and there's details about that. So it's disingenuous to say that he's not going to be judged by his appearance.
Literally, so you guys threw a fit about cameras because some body language person did some analysis about him, maybe the way he turns his head or whatever, and the way he does like this, and like a come on. They also acted like the media was zooming in on their papers. Nobody was doing that. Nobody was doing that. Everybody knows you don't shoot stuff on counsel table. It just drives me crazy.
That is exactly what jurors are doing. They're judging the evidence. They're staring at the accused. They're looking for an accused to be remorseful and emotional at evidence that makes everybody else feel bad. And he is not capable of doing that through no fault of his own.
I don't know if I agree with that because I don't know. I mean, what is a defendant supposed to do? Like, if a defendant is going into court and saying they're innocent, they're not guilty, and that they're innocent, what are they supposed to do? What are they supposed to cry? Are they supposed to shudder? If a gruesome crime scene photo is put up on the screen, like if something is really, you would think normal people, when I say baseline normal, I mean, your average human being who does not look at crime scene photos for a living. I mean, homicide detectives look at crime scene photos for a living. But I think we're going to probably see, the people in the courtroom will see some pretty awful things in this trial. I guess I would want to speak to a defense attorney who's done a lot of big homicide cases. Like, how do you talk to your clients about how to react to this stuff? Like, how do you have to coach them or counsel them on their demeanor? So what is she expecting from him? Yeah, he might not react. I mean, he was studying criminology. We don't know what was on his laptop or whatever. So I don't know. I don't know. So Judge Hippler, here we go, guys. Dry sass denied the defense's motion to strike the death penalty. Sorry, I'm trying to pull the right one up here, guys. Here it is. Yeah, I got all three of them pulled up here that we're going to go through. And they were talking about all these approaches they were going to use. We're not going to go through. We're not going to go through every little, bit of minutia. But we're going to just hit the highlights. The court finds striking the death penalty is not warranted. Judge Hippler talked about how there were basically two doctors in this case who have diagnosed Bryan Kohberger with autism spectrum disorder, level 1. That's the highest functioning level. It used to be called Asperger's syndrome. And so basically those deficits can include restricted range of affect, atypical eye contact, displaying facial expressions or movements that do not match what is being said, failure to consider social cues, and having trouble with speech reciprocity and repetitive behaviors. So they go through all of this stuff. The second criterion, let's see. Oh, they're going through all this criterion. I need to get that program where you can highlight stuff. His family and peers reported his inability to adjust his behavior to suit the social context, poor social reciprocity and conversation, issues with nonverbal behavior like personal space. She notes these difficulties played a role in the eventual termination of his funding for his graduate program. At the time of his arrest, he was pursuing his PhD at Washington State. She observed some typical social behaviors, fairly consistent though intense eye contact, polite demeanor and social conventions, shaking hands upon greeting. He engaged in conversation and was never overtly inappropriate. However, Dr. Orr also noted social behavior consistent with that reported by others, such as lack of fluidity in his verbal interactions. He makes awkward comments. Has abrupt responses, inconsistent understanding, acknowledgement of humor, and occasional intense gaze. She noted he had poor reciprocity of interaction, including very frequent refocus of conversation back on his own experiences or unusual responses to my sharing. She also noted his lack of close friends and his poor insight into his role in relationships. Dr. Orr further observed deficits in defendant's nonverbal communication, noting poor integration of verbalization and eye contact, limited use of descriptive gestures, restricted range of affect, atypical tone. As to his speech, Dr. Orr observed that defendant was generally clearly articulated and his speech was appropriate in rate and volume, but overall monotone. His language was generally appropriate in content and form with an extensive vocabulary, but overly formal, and highly repetitive with scripted phrases. And when he talks, he says like stuff like, objectively speaking, mind you, to be fair, and moral of the story. She talked about the occasional subtle rocking of his upper torso while seated and scripted and repetitive language. And he appeared fixated on the routine of timing of breaks and procedures during the examination. He also demonstrated rigidity in his thinking and behavior. He wanted to know the results of his testing, and he was highly interested in circumscribed topics such as forensic psychology, intellectual topics, and Murakami. I looked up Murakami, and all I could find was this author from Japan who writes a lot about loneliness and isolation. I thought that was interesting. She noted he was highly distracted, etc. His neurological profile revealed a high average intellect at baseline. Full scale IQ was 119, which is the 90th percentile for his age. That's pretty good. He showed strong verbal abilities, abstract reasoning, memory, concept formation, and reading skills. However, he displayed weakness in executive functioning, such as planning, cognitive flexibility, impulse control, and organizational approach. He perceives information in a piecemeal manner rather than looking at the whole picture. He was given a level 1 diagnosis without intellectual impairment, which is the least severe level. There was a second doctor, Dr. Ryan. She basically agreed with Dr. Orr's diagnosis. She said he's highly intelligent and has a factual understanding of the proceedings against him, the penalty he is facing, pleas, and the roles of courtroom personnel. So she's saying he understands what's going on. They've tried to say he's not competent, or that they have not said he's not competent. I apologize. They've said competency is monitored continuously and that it's a concern. Yeah. So I'm going to go to the end of this because the state's basically saying there's no other place, no other state says that people with autism can't be executed or can't face the possibility of the death penalty. So let's go to the end to see what the judge said. At the end, he says, as the state points out, there's no precedent for striking the death penalty due to media coverage. Further, any concerns that arise from such media coverage can be mitigated through voir dire and from expert testimony and evidence during the penalty phase of the trial. And then basically he said, in sum, not only has defendant failed to show that ASD is equivalent to an intellectual disability for death penalty exemption purposes, he has not shown there is a national consensus against subjecting individuals with ASD to capital punishment. ASD may be a mitigating factor to be weighed against the aggravating factors in determining if a defendant should receive the death penalty, but it is not a death penalty disqualifier. So he's saying bring it up if he's convicted in the penalty phase. So he says no dice. to the defense on that one. So Von Krull says, I'm on the spectrum somewhere myself, and I can definitely enjoy a laugh about autism. It depends on the spirit behind the joke. If you're just tuning in, thanks so much, guys. I appreciate it. Remember to like and subscribe. Hit that thumbs up button. I really appreciate it. Would appreciate it if you would. And let's watch Mad Router. I'm an ICU nurse, so I'm always on replay crew. So it's cool to catch her live. I've been watching her for years on LNC. Mad Router, thank you so much. I appreciate that. Thank you so much for tuning in. It's great. I appreciate it. Please like and subscribe. And if you are watching on replay, I love it when people watch on replay. It's so cool. Thank you so much. So the autism argument did not work. The judge, there are some mental illnesses that do qualify. I will just tell you that. Like here in Ohio, there are some mental disorders in which they're saying like that you can't be put to death if you have them. And I forget which ones they are. And I think they pointed to those cases, the defense did, or into that statute here. It's Ohio and Kentucky. In Ohio, it's like there's like a list of disorders, mental disorders. But they were saying like, in Idaho, you can't, there is no mental health, insanity defense. And that's not what they were saying. They were saying this was like a neurobiological issue. So if he were in Ohio, he wouldn't matter even if he was in Ohio or Kentucky, because it's more like schizophrenia and stuff like that, like serious mental health disorders, where you become ineligible for the death penalty, I believe. Okay, guys, so let's move on now to some of the other stuff. There was vague testimony, vague and undisclosed expert testimony. So the defense has basically already said what their defense is. The defense has basically said Bryan Kohberger did not do this. They're going to present an expert who said that one person could not have done this and that there were two killers. And part of the reason they're going to do that is because there were those two unidentified male DNA specimens or whatever found at the house. So let's listen to Ann Taylor.
Your Honor, we have produced an expert that believes that it's likely that there were two people, two weapons. That
Dawson testimony about the degree of intoxication goes to the what I'm assuming was, given that degree of intoxication, the ability to fight back. In rebuttal to your experts, as I understand it.
I think that's what the state says. I don't think that's proper rebuttal. Well, because we didn't talk about intoxication, because the state's medical examiner talks about defensive wounds anyway, so this would seem to be contradictory with other testimony that they intend to put on.
Okay.
We are not contesting the intoxication level of any of the deceased.
I understand your argument.
Thank you.
So basically, Ann Taylor, they're going to say that there were two weapons. They have an expert who's going to say there were two weapons used. So in rebuttal, the state wants to call an expert who's basically going to say, well, yeah, one person could have done this because Maddie Mogan was really intoxicated and there was no way she could have fought back. That's how intoxicated she was. So that leads me to believe, as Steve Gonsalves has told other people, other media outlets, that, Kaylee was able to somehow fight back. There's this expert that the defense wanted Judge Hippler to say this expert, Gary Dawson, can't testify. So this Dawson guy said Madison Mogen would have been markedly intoxicated from the effects of alcohol around the time of her death. She would not have had the ability to mount a meaningful response to a sudden threat to her person. He further states that while he has limited his review to Maddie, the same general principles apply to the other victims. So he's saying the others were so intoxicated too that they wouldn't have been able to meaningfully defend themselves. But it sounds like he focused on Maddie for whatever reason. That makes me think that backs up in my mind the theory that she was first, that she was definitely asleep and possibly was the main target. They're saying it's proper rebuttal. The state says the opinion rebuts defense expert Brent Turvey that more than one assailant was necessary to accomplish the crime in the time frame alleged. Specifically, the state argues that evidence Ms. Mogen was unable to effectively fight back supports its position that one assailant could have completed the homicides in a short time. So Mr. Turvey has opined in his report that 2 assailants were involved in the homicide, partially because he believes multiple weapons were used against Kaylee Gonsalves. Inferred in this opinion is that one person would not have had the time or the ability to use multiple weapons in the time frame alleged when faced with 2 victims. If Ms. Mogen was intoxicated to the point of being unable to fight back, however, it would be possible for one suspect to incapacitate her and then use multiple weapons in attacking Ms. Gonsalves. So was there more than one weapon involved? That's entirely possible, but it doesn't mean that it had to be 2 people to do that. That's really scary. The whole thing is horrifying and terrifying. So this guy's testimony is going to be allowed. Then let's go back up to we've got some other experts. Let's see. The Barnharts. The Barnharts have some interesting things to say about Heather and Jared Barnhart are Celebrate experts. And digital specialists, and they are going to testify about the defendant's cell phone and PC to determine user behaviors and actions. They're going to talk about gaps in data on the 2 devices of Bryan Kohberger's that they deem abnormal. Defendant argues that the disclosures indicate that they will testify to habit evidence, which he complains is not explained. But apparently, the disclosures say that they will testify to their findings pertaining to defendant's activities on his PC and cell phone for a period of time before and after the homicides, and why gaps in data over that time are abnormal. The Barnharts opinions regarding these topics are fully set forth in their joint report. They observed gaps in defendant's school PC that may be consistent with cleaning up or using anti-forensic methods to clear evidence. That's really interesting. So that's like, is that wiping software? I've heard people talk about that. Among the gaps found were in the PC's event logs and system resource usage monitoring between November 11th, 2022 and November 16th, 2022, which the Barnharts opined was abnormal given that school was in session. Likewise, they located gaps in the PC's Chrome history during dates where downloads occurred on the system, indicating the user was private browsing or clearing browsing history. Together, the Barnharts disclosed a joint report set forth for all that is required. So he's not going to limit their testimony. Then they talk about Michael Douglas, the FBI guy, the forensic accountant. Apparently, Bryan Kohberger stopped using his debit card after November 10th and started he had regularly used his debit card, but there's no indication about why he's going to testify about that and why he started using cash instead. Even the judge is like, I don't know why that's relevant, but the defense hasn't brought that up, hasn't argued about this on relevance. Nick Balance's testimony is going to be allowed in, the cell phone guy. Then you've got this Darren Gilbertson, one of the lead investigators from Idaho State Police. He is literally going to testify that he did dry runs through the house and that they believe the homicides could have occurred. They could have been carried out in between 2 and 4 minutes. That's, I mean, maybe, but that seems super fast to me. But I've also never carried out 4 homicides. So yikes. And the judge took the defense apparently said, well, he did this before they tore down the house and now we can't do our own tests. And the judge was like, well, tough. You stipulated, you knew that he did this and you said they could tear down the house. So tough. I was like, that was kind of funny because I mean, they did. They said, go ahead and tear it down. So there you go. Let's see. Okay, let's see. I might have skipped this part too. I read through this earlier. I might have skipped this part about the stuff from this is just chain of custody stuff. It doesn't look that okay, this doesn't look like it doesn't look that interesting, guys. Sorry. I missed that part of it. So anyway, all that stuff was denied by Judge Hippler, the whole vague and undisclosed expert testimony. He's like, no, you guys got what you needed. So there you go. Yeah, I heard about this. Christina Franz says the other weapon may be the fist that SG mentioned. I heard that he said something on a YouTube channel about her being punched in the face. So yeah, I'm going to get to this. D, I'm going to get to this. He's granted a couple of things to the defense, but not much. So guys, let's get now to the 911 call. So basically, Hippler has said, he may grant some of this stuff and may not grant some of it. But for the 911 call and text messages, for the 911 call, some of it's going to have to be redacted. Yeah, Mad Router, I agree. The 911 call, I mean, there's so many different people on there. And he's saying, some of this stuff isn't really present sense impression because it's so much time had elapsed. So, and he expressed that at the hearing. So he let's see. Let's go to the new information. So this is I'll go to the ruling. So sorry guys. My throat's getting a little scratchy here. So basically he has this is what he seems to like to do, Hippler. The state's motion in limine, RE text messages is and the state's motion in limine regarding the text messages and testimony is granted. They wanted to introduce the text messages. Granted in part and reserved in part. The state's motion in limine regarding the 911 call is granted in part and denied in part and reserved in part. So he splits the baby a lot here on some of these. He denies some of this stuff outright, and then he kind of splits the baby on a lot of this stuff. So let's go up here. He kind of lays out the facts of what happened up here. Sorry, guys. I'm looking. I lost my space here. Did I share my screen yet? Share screen. Oh, sorry, guys. I'm still kind of, yeah, I'm not sure they'll care about the 911 call either. Sorry, I'll take that down. Oh, hi, Truth and Transparency. The docket, it's a saying. Nobody's really splitting babies. Sorry. Maybe I shouldn't use that terminology in a case like this. Okay, guys. So they talk about, so the judge talks about the 911 call, the text messages. After spending the evening out, the roommates, DM, BF, Kaylee, and Maddie, calls her Morgan in here. That must be obviously a typo. They went back to King Road in the early morning hours of November 13th. They're all home at 2 a.m. So think about the King Road house. Let's all envision the King Road house. It's 2 a.m. College girls, they're, I mean, they're drunk. Like, let's just be, blunt about it. They were drunk. I mean, it's not that they're college girls. And so this says they all met up in Kaylee's bedroom and talked for a while before going to bed. So you can probably imagine this. They're hanging out and they're in Kaylee's bedroom. Maybe the dog is there. The four girls, and Xana and Ethan were over at the Sigma Chi house, and the Sigma Chi house is not far from there. I kind of wish I had the drone video pulled up right now. We have some really great drone video at work that kind of shows everything. So they're over at Sigma Chi. They debated going out to the food truck for a late night snack. DM sends a text to an Uber driver to see if he was driving. But the girls, they just decided to go to bed. At 4 a.m., DM heard strange noises and crying coming from the bathroom, which she's saying this is coming from the bathroom. So I'm kind of like, what was going on in the bathroom? She opened her door at one point. And did I share my screen? Yeah. Sorry, guys. She opened her door at one point and saw a man dressed in black with a ski mask on walking by her bedroom door. She then placed calls and texts to her other roommates to see if they were awake. Only BF, who was on the ground floor, answered. They spoke for 24 seconds, during which DM told BF she thought she heard something. They spoke again a minute later for 41 seconds when DM told BF she saw a man in a ski mask leaving the house. So there's a footnote. Let's go down there. BF testified to her recollection of the content of these two phone calls before the grand jury. However, DM could not recall specifics about what was said. So that's interesting. So they exchanged the following text messages between 4:22 and 4:26. DM to BF, no one's answering. DM then says, I'm really confused right now. DM to Kaylee. DM to BF, what's going on? BF to DM, yeah, dude, WTF. BF to DM, Xana was wearing all black. So on this phone call, there must have been some discussion about, I saw somebody wearing all black, like in a ski mask. DM says to BF, I'm freaking out right now. DM to BF, no, it's like a ski mask almost. BF is like, basically like STFU, like, what are you talking about? And then BF says to DM, actually, and DM to BF says, like, he had something over his forehead and little in mouth. DM to BF says, Bethany, I'm not kidding. I'm so freaked out. Okay, guys. So here's kind of like what the cops showed to, here's what the cops showed to DM like a few days later, the balaclava. DM says, Bethany, I'm not kidding. I'm so freaked out. BF says to DM, so am I. DM says to BF, my phone is going to die. F word. BF to DM says, come to my room. BF to DM says, run. BF to DM says, down here. DM to BF, I'm scared though. BF to DM, yeah, I know, but it's better than being alone. During the foregoing exchange, DM also attempted contacting Ethan Chapin through Snapchat. She again tried calling Kaylee and Xana, but neither responded. And this is according to grand jury testimony. DM then exited her room and began running toward BF's room. On her way, she noticed Xana lying on the floor of her bedroom with her head towards the wall and her feet toward the door. DM thought the Xana was drunk. Yikes. So, you know, in listening to that 911 call and seeing those text messages, I mean, the text messages were before she apparently saw this. I would never have thought, that I would never have thought that she saw Xana, that like when she was going down there. I got to close this. I don't want people to hear me saying this stuff. I would never have thought that DM actually saw Xana on the ground. I really didn't. I really would never have thought that. So DM told the grand jury she actually saw Xana on the floor as she's running through. And I'm going to let's pull up a picture. There are pictures of the King Road house, the interior. Okay, guys, I'm going to show you. So let's share this really quick. Oh, thank you so much for the super chat. Here, let me show you guys. I wish I had a better picture of this, but I just don't. So you guys see this. So, oh my gosh, the picture moves. How helpful. Okay, but this, it's helpful. Oh, it doesn't really move. Sorry. I was confused. So here we go. So there's like, you've probably seen the TikTok video that sectional couch was like right there. This is DM's room right there. Okay. So DM would have come through here. That one green grassy sign would have been here with the good vibes neon sign. So she would have come through here, right? She's running through. She's running through to go downstairs to Bethany. Can you guys, when I'm doing this, do you actually see my cursor? When I do this, are you guys actually seeing my cursor on the screen? So DM comes through here. Xana's room is down that hallway. I hope you're seeing my little thumb thing on Chrome or whatever. So that's Xana. She would have like been like this, running, because she ran this way to go down to see Bethany. So she would have been running past here and looking down that hallway. The good vibes sign was lit up here. And then there was some like twinkly lights somewhere else, I think over here. She would have run down here and maybe like looked down there and seen Xana on the floor. And she thought she was drunk. And then there's a bathroom down there too. Wow. You know. Ethan was in the bedroom. So Ethan was in the bedroom. Right. So sorry. So yeah, I was under the impression that the door from hearing the 911 call, my analysis of this from listening to that 911 call, it sounded like knocking. I thought the door was closed. And maybe Hunter or HJ, whatever Hunter was knocking. Mad Router says, just tells me she's used to seeing her roommates passed out drunk. Yeah, I don't know. I don't know. I mean, but maybe I can see like you hear, maybe you hear crying. Maybe you think your roommate's been throwing up or something in the bathroom. And I mean, you don't think something like that has happened. But there's DM's room right there. Over here is where the sectional couch would have been. And then there's that stairwell that goes down to the ground floor. So she would have come out here and gone around there. And then down that hallway was Xana's room. Let's see what else we can see on these pictures. There's some other picture I had found online that showed the good vibes sign and everything, but now I'm not going to be able to find it now that I want to find it. So anyway, so let's go back to this one. Well, I say because she's like, what, 20 years old, 19 years old, something like that, and she's drunk and doesn't really know what's going on. I don't know. And you just saw some weird guy in your house. So I don't know. I mean, there's a lot of questions, right? Oh, sorry. Let me take this down so we can continue to read. Sorry. Let's see. Okay. Once DM arrived at BF's room, they locked the door and both made additional unanswered calls to the other roommates. At 4:32 a.m., DM again texted Kaylee, please answer, with no response. Between approximately 5 a.m. and 6:30 a.m., DM engaged in activity on her phone, primarily creating, editing, and deleting images and videos. Her phone activity then ceased until 8:05 when DM accessed Instagram for a few minutes. At 10 a.m., DM again accessed Instagram and communicated over Snapchat. At 10:23, she texted Madison again, are you up? She received no response. DM continued to access Instagram and Snapchat until 11:29 a.m. when she texted Kaylee, are you up? So a lot of people were like, what is she doing on Snapchat and stuff? And I think we kind of theorized or thought she might be trying to get a hold of the roommates. Again, there was no response, which DM thought was strange because Kaylee and Madison were early wakers. DM continued accessing various social media sites, including checking Ethan and Xana's Snap Map locations. At approximately 11:40, DM's father texted her about scheduling a time for a chat, to which DM responded. She also received 2 texts from a person named Jenna stating, bro, and do you guys need me to come get you? At approximately 11:50, DM called her friend EA and asked her to come over and check the house because she was scared. EA and her boyfriend, HJ, came over. So EA, I guess, is the young woman who lives next door. They met DM and BF at the bottom floor of the house. DM, BF, and the HJ started to walk up the stairs to the second floor. When they reached the second floor, HJ went to the kitchen to grab a kitchen knife. When he came back out, DM saw Xana again for a split second, and I just started bawling because I thought she had just I don't even know. I thought maybe she was still drunk and all asleep on the floor. BF also saw Xana lying on the floor. HJ told DM and BF to get out. EA, who had started up the stairs, also turned around after HJ instructed her not to come any further. They both went outside. Shortly afterwards, HJ exited the house and told them to call 911. So this is this is like before the 911 call, which is wild. He was pale white and mentioned something about someone being unconscious. At 11:56 a.m., BF called 911 from her cell phone and spoke to the 911 call taker, Carolina Calvin, the 911 dispatcher. The call lasted 4 minutes and 11 seconds. During the call, the phone was passed around to different individuals, including BF, DM, HJ, and an unidentified female speaker. Heaving, heavy breathing, and crying can be heard throughout the call. BF spoke first, stating something is happening. Something's happened in our house and we don't know what. BF attempted to provide the address of the house to dispatch, but could not continue. At that point, the unidentified female speaker took the phone and provided the address and BF's phone number, and the following exchange ensued. We kind of know what happened here. I guess I could play part of it really quickly. I don't think we need to play the whole thing. Sorry, guys. I'm pulling up the 911 call. I should have had it already queued up.
a.m. 42 seconds, November 13, 2022.
Can you guys hear this? Are you guys hearing the call? I'm just making sure. Can you guys not hear the call? Oh gosh, I'm so sorry, guys. I shared my screen and I played it. Goodness me, I'm so sorry. It was like 2 screens were up and I must have exited out of the wrong one. Here we go. We'll just listen to a little bit of it. Is it not playing?
Eleven 55 a.m. 42 seconds, November 13, 2022.
911 location of your emergency.
Hi, something is happening. Something happened in our house. We don't know what.
What is the address of the emergency?
1122.
What is the rest of the address?
Oh, Kings Road.
Okay. And is that a house or an apartment?
It's a house.
Can you repeat the address to make sure that I have it right?
I'll talk to you guys. We live at the White, so we're next to them.
I need someone to repeat the address for verification.
The address, 1122 King Road.
And what's the phone number that you're calling from?
What's your phone number?
And tell me exactly what's going on.
One of the roommates has passed out, and she was drunk last night and she's not waking up.
Okay.
Oh, and they saw some man in their house last night. Yeah. Hi, this is.
And are you with the patient?
Oh, okay. So we'll get out of that now. So, DM then informed dispatch that Xana was 20 years old. HJ took the phone. Dispatch asked him if she was breathing. Let me go back to this. The state wants to admit DM and BF's phone records, including call and text messages, as well as elicit testimony by DM and BF regarding their communications with each other on November 13th, as they testified in front of the grand jury. State also seeks to admit the 911 call and the official transcript thereof. State argues these records and communications are not hearsay, or they are accepted from hearsay as excited utterances or present sense impressions. Defendant objects, arguing that apart from HJ's statement to 911 that Xana was not breathing, the exceptions do not apply. The court finds the bulk of the statements are likely admissible, with 3 exceptions of statements made during the 911 call. And he cites a bunch of case law. So there's going to be 3 things that aren't going to be allowed. He's saying that the court finds DM and BF's acts of making phone calls, sending and receiving text messages, and other phone activities, such as accessing social media, are not hearsay. As to the content of DM and BF's text messages about what DM saw, the court finds they are either not hearsay because they're not offered for the truth of the matter asserted, or not assertions, or if hearsay, they likely qualify as a present sense impression and or excited utterance. The state wants DM's text to the Uber driver admitted to at 2:10 a.m. to establish a timeline, but the defendant's not challenging that. The court finds it's not hearsay. Text messages between 4:22 and 4:26. The state argues the 4-minute series of text messages between DM and BF, with one from DM to Kaylee, are admissible as either present sense impression or excited utterances. Defendant suggests neither exception applies because there is no evidence they were sufficiently startled by the events. He points out that DM claimed only to be confused, and despite stating she was scared, she ran to BF's room instead of leaving the house or otherwise calling friends and family for help. The court agrees with the state for those texts qualifying as assertions. So basically, he's going to let the text messages in. So I'm kind of scrolling through this kind of fast. I'm looking to see if he's going to let in that lady. So there's the initial statements. The 911 call begins with BF telling dispatch something is happening. Something's happened in our house and we don't know what. This statement falls squarely within the present sense impression exception, given that BF was experiencing concern that something was wrong with their roommates, and HJ had just instructed her to call 911 after walking through the house. Thereafter, BF attempts to provide dispatch with the address of the house before an unidentified female speaker takes the phone and provides the address and BF's phone number. This exchange is not offered for the truth of the matter asserted and therefore not barred by the hearsay rule. My dog just knocked something over in here. Number 2, female. One of our roommates who's passed out and she was drunk last night and she's not waking up. The state argues the statement is a present sense impression because the female speaker is describing the scene around her. However, as defendant points out, the roommate at issue in this statement is Xana. The only individuals who experienced or saw Xana unresponsive were DM, BF, and HJ. Thus, defendant contends the exception does not apply because the female speaker never saw Xana unresponsive and thus lacks firsthand knowledge of the information contained in the statement. So that's not going to be admissible. He's not letting that in under the exception to the hearsay rule. And then the female saying, oh, and they saw some man in their house last night. Yeah. Let's see. So that's going to be redacted, the neighbor saying that. DM's attempts to explain the events. that's going to be redacted. I don't really know, but pretty much at 4 a.m. that's going to be redacted. Statements regarding Xana. Dispatcher then instructs DM to find out if someone is passed out. DM appears to make statements to bystanders that they have to go check. It's a present sense impression, so that's going to be allowed in. Statements after law enforcement arrive. HJ confirmed to dispatch that Xana was not breathing. Law enforcement had arrived on scene. HJ can be heard telling DM, I need you to talk to them. I can't talk to them. I need you to talk to them. So that's going to come in too. So sounds like the rest of it's coming in. So guys, there you have it. That's the very latest. So parts of the 911 call are coming in. The text messages are coming in. The death penalty is staying on the table. For now, they're trying one more thing to get the death penalty stricken. They're saying there's way too much discovery, 68 terabytes, and judge, you need to strike the death penalty. So that's their next try at this. And my dog is going crazy. Sorry, guys. So that is it for tonight. I'm going to take a look at the poll. Remember to vote in the poll. Do you want me to talk about Karen Reed tomorrow? Because I can, and I think I should, because it's a wild case and it was some crazy stuff that happened in court this week. But there's still a lot more to talk about with Bryan Kohberger, so we'll continue to talk about that too. So again, thank you so much, guys, for watching, for tuning in. Remember to like and subscribe. And there's still more we can talk about with this. And Cindy is going to come on and join me one night. And we're going to talk about the local angle of this. There's a lot to talk about still. We have a whole trial coming up. Ms. Tree says, why did DM make new contact of driver of KG and MM? I don't know. I don't know. Let's see. I should look and see if you guys had some questions really quick. I'm sorry. I got kind of distracted. My dog knocked over my ring light and then she couldn't get out and started barking and like going crazy. So I apologize. Let me look at some of your, questions before I log off. Yeah, sorry. I just popped in and was like, what's she doing? I don't see her hear anything other than Anjanette drinking her water. Hilarious. Yeah, I thought I was playing the 911 call for you guys. So I had 2 windows popped up with it on and exited out of the wrong one. So I apologize. So sorry about that, guys. But yeah, again, thank you so much for tuning in. I will let you know as soon as I can tomorrow about whether or not I'm going to do a Karen Reed thing. If I do, I'll come on. But I think it's worth talking about because I think this is a completely different trial again, and there's still a lot more to talk about with the Kohberger case, and we will do that. And there's a lot of other cases that I still need to talk to you about too. So we will do that as well. So again, if you're watching on replay, thank you so much. I love that. I appreciate it. And like and subscribe, and I will see you back here another time. Have a great night, everybody. Bye-bye.